Welcome to the law offices of Chris M. Ingram's Immigration News Show. Today we ask, does the court striking down the $100,000 fee change anything for people who already have an H-1B visa? We would like to thank attorney Chris M. Ingram and staff at the law offices of Chris M. Ingram for their hard work in preparing the research for this show, which draws on a wide variety of news sources from both sides of the aisle, providing a balanced view. Attorney Ingram is also a vocal advocate for the rights and protection of immigration applicants, although our coverage is designed to be nonpartisan. Please don't forget to like, follow, and subscribe to our channel. We are also on Spotify, YouTube, LinkedIn, Facebook, X, Reddit, and Instagram, where we're growing rapidly thanks to our social media team. You can also visit our website on www.breakthroughusa.com. We'd love to see you there. Disclaimer. Please note that this presentation should not be intended as legal advice for your specific situation. If you, a friend, or a family member would like a free consultation, you can visit our website at www.breakthroughusa.com and schedule an appointment. We'd love to hear from you and help you if we can. We'd also like to point out that this presentation was created using AI hosts. Okay, let's dive in.
Thank you. It is really great to be here today for this deep dive. We've got a lot of ground to cover.
We absolutely do. I mean, imagine getting your absolute dream job, say a tech job in Texas. You've gone through, what, like 5 grueling rounds of technical interviews?
Oh, at least 5. Probably a coding test, too.
Right. And you've packed up your entire apartment back in India. Your family's incredibly proud of you. Everything is set. And then, literally right before you're supposed to move, your new boss calls you.
Yeah, the dreaded phone call.
And they say, hey, so the U.S. government just sent us a mandatory bill for $100,000 to process your paperwork. And we literally cannot afford to hire you anymore. We have to freeze your start date. For 7 agonizing months, that was the terrifying reality for international talent. Until yesterday.
It was. I mean, it was an absolute systemic shock to the whole system. When we look at the legal research prepared by our team for today, the sheer scale of the disruption becomes incredibly clear.
Yeah, it's wild.
Because on September 19th, 2025, a presidential proclamation came down, and it just completely broke the financial mechanics of the H-1B visa. We are talking about spiking the cost from a few $1,000s to $100,000, essentially overnight.
Which is just, I mean, that's an unfathomable jump. And what we are looking at today is the resulting legal earthquake from that. Because on June 8th, 2026, a federal court in Massachusetts completely struck that fee down.
Right, and it's a massive decision.
So our entire focus today is analyzing this 42-page ruling, which was identified by Judith Merslin, the head of casework and compliance at the law offices of Chris M. Ingram. We are going to dig deeply into the mechanics of this decision based on the research from attorney Chris Ingram.
Exactly. And we really need to clear up the massive amount of confusion spreading online right now.
Oh, the forums are a mess right now.
They really are. So we're going to figure out the exact tactical moves that employers and skilled workers need to make today. But, before we get into the really complex constitutional law arguments like the taxation clauses and the administrative procedures, we have to look at what this actually did to the people on the ground.
Yeah, the human element. Because the human toll is what ultimately drove this all the way to the federal courts.
Right. Our legal team provided a fascinating case study in their research that illustrates the exact mechanics of this freeze. We are looking at a young man named Vikram. He grew up in Chandigarh, India. And
his background is super intense, right? The research notes he gained admission to IIT Delhi.
He did. And for those listening who aren't familiar with the global engineering landscape, getting into an IIT is, well, it's statistically harder than getting into MIT or Harvard.
Wow, really?
Oh, absolutely. The acceptance rate is notoriously low. I mean, it is a life-defining achievement. It carries the weight of an entire family's expectations.
Right. So you have a candidate who has survived one of the most rigorous academic gauntlets on the planet. He graduates, he navigates the international job market, and he successfully lands this great mid-level engineering role in Austin, Texas.
Yeah, and his base salary is set at $95,000 a year. So in late 2024, his employer files the H-1B petition, it gets approved, and everything is in motion.
And then the September 2025 proclamation drops. And suddenly, well, the toll booth costs more than the cargo. The fee to bring him over is $100,000, which, if you do the math, is over 100% of his first-year salary.
Exactly.
I want to look at this from the employer side for a second, because I think a lot of people outside the corporate world wonder, well, if it's a big tech company, they have billions. Why don't they just pay the $100,000? How do corporate immigration budgets actually handle a shock like that?
Well, the short answer is they don't. I mean, corporate finance operates on very strict forecasting and P&L profit and loss margins.
Right, it's all spreadsheets.
Exactly. When a company budgets for a new hire, they factor in base salary, benefits, equipment, and standard onboarding costs. Standard immigration legal fees and filing fees are, they're baked into that overhead.
Because it's a known cost.
Right. But when you introduce a sudden, completely unbudgeted $100,000 liability per employee, the internal rate of return on that hire just plummets to negative. The CFO looks at the spreadsheet and says, we would be losing money by employing this person for the first 2 years.
Wow.
From a fiduciary standpoint to their shareholders, they literally cannot justify the expenditure.
So it's not even a question of whether they like the candidate or how smart he is. The math simply breaks. I mean, it's like, okay, think of it like buying your dream house.
Okay, I'm with you.
You pass the inspection, you get the mortgage approved, everything is great. And then the day before you move in, the city invents a new closing tax that somehow costs more than the house itself.
That is a perfect analogy.
Right. Like, okay, let's unpack this.
Yeah.
How is a business supposed to function when the toll booth costs more than the cargo? So the company told Vikram they needed to reassess. That was the exact word they used.
Which is such a corporate word. And it left him in a complete state of limbo for 7 months. He wasn't rejected, his visa wasn't denied for the lack of merit, but he was just completely paralyzed.
Yeah, just stuck. And while he was stuck, the global talent market was shifting, wasn't it?
Massively. The research indicates that during this 7-month window, aggressive recruitment from countries with more streamlined systems just skyrocketed.
Right, cool.
Places like Canada with their Express Entry program, or the UK's High Potential Individual Visa. Vikram was basically sitting there watching his peers give up on the U.S. entirely and take lucrative offers in Toronto and London.
Right, because other countries don't have this massive barrier. It's essentially a massive financial scarecrow. And the crazy thing is, the government didn't actually need to collect the $100,000 from everyone.
No, they didn't.
They just needed the threat of it to scare companies away from the field entirely. Which brings us to the core of the legal battle. If the federal government issues a proclamation like this, how do you even fight it?
Well, it's not easy, but the research from our attorneys details this incredible June 8th ruling by U.S. District Judge Leo Sorokin in Massachusetts. The case is called State of California et al. V. Marquain Mullen et al.
Let's look closely at the plaintiffs here, because it really sets the stage for the entire legal argument, doesn't it?
It does, because this wasn't Vikram suing the government. This wasn't a massive tech company like Google or Apple suing the government.
Right.
This was a coalition of 20 Democratic state attorneys general, spearheaded by Rob Bonta of California and Andrea Joy Campbell of Massachusetts.
Okay, I really want to push on that for a second.
Yeah.
If I'm an employer in Texas or a worker from India like Vikram, why is the Attorney General of Massachusetts fighting my battle? How does a state government even have the legal standing to sue the federal government over an immigration fee that applies to private companies?
It's a great question. It comes down to a legal doctrine called parens patriae, which is Latin. It essentially means the state is acting as the parent of the country, or the ultimate protector of its citizens and its economy.
Ah, okay. So they are stepping in to protect their own backyard.
Exactly. But to get standing in federal court, to even be allowed to bring the lawsuit, a state has to prove direct harm. They can't just say, this is unfair. California and Massachusetts didn't just argue the fee was unfair to individuals. They argued it was doing catastrophic, measurable damage to the state's sovereign interests.
Meaning what? Economic damage? Like losing tax revenue?
Precisely. The states argued that by pricing highly skilled workers out of the market, the federal government was directly harming state tax revenues because those highly paid workers pay state income tax. But furthermore, it was damaging the state university systems.
Oh, that's interesting. How does it hurt the universities?
Well, international students pay premium tuition at state universities, and they do that largely because of the pipeline that allows them to transition to the U.S. workforce via the OPT to H-1B route.
Right. They see it as an investment.
Exactly. So if you kill the H-1B route with a $100,000 fee, international enrollment drops off a cliff, and state universities suddenly lose millions in funding.
That makes perfect sense.
Yeah.
They basically have to show the court the receipts. Look, this policy is burning a giant hole in our state budget.
Yeah.
So once they establish they have the right to sue, what is the actual weapon they use to strike the fee down? Because the core legal argument they used is fascinating.
It really is.
The research points out they didn't actually argue immigration law, they argued tax law.
Yes. This is the absolute crux of Judge Sorokin's 42-page decision. The states argued that the $100,000 charge was unconstitutional because it was not a fee, it was a tax.
Okay, and why does that matter?
Because under Article 1 of the U.S. Constitution, only the legislative branch, meaning Congress, has the power to levy taxes. The executive branch, which issued the proclamation, cannot simply invent a new tax.
I feel like we really need to clarify the mechanics here. Because to the average person listening, a fee, a tax, a penalty, it all just feels like money leaving your bank account and going to the Treasury.
Right, it all hurts the wallet the same way.
Exactly. So what is the precise legal distinction that Judge Sorokin had to make? Why does the label matter so much?
The label determines which branch of government has the authority to act. So let's break down the three categories. A legitimate government fee must be directly and mathematically tied to the cost of processing a service or providing a benefit.
Like paying for a driver's license.
Yes. When the United States Citizenship and Immigration Services, USCIS, sets standard filing fees, they undergo a rigorous, years-long fee study. They calculate the exact cost of the paper, the background checks, the adjudicator's hourly wage, the overhead of the physical buildings. It is strict cost recovery.
And obviously, adjudicating a single H-1B petition does not cost the federal government $100,000 in administrative overhead.
Right. It completely fails the legal test of being a fee because the number is entirely arbitrary. It's totally detached from the processing cost. So when the administration's lawyers realized that wouldn't hold up, they tried a different angle. They tried to frame it as a penalty.
But wait, a penalty requires someone to have done something wrong, doesn't it? Like a speeding ticket.
Exactly. In the legal sense, a penalty is a punishment or a deterrent for illegal conduct. You pay a penalty for violating environmental regulations or, breaking a traffic law. But applying for an H-1B visa is entirely lawful conduct.
It's encouraged even.
It is. In fact, it is a legally established immigration pathway explicitly created by Congress to benefit the U.S. economy. You cannot legally penalize an entity for participating in a congressionally mandated lawful process.
Okay, so if the math proves it isn't a cost recovery fee, and the law proves it isn't a penalty for illegal conduct, what's left?
What is left is a revenue-raising measure imposed on lawful conduct. And by strict legal definition, that is a tax. Judge Sorokin was unequivocal in his ruling on this. Because it is a tax, the executive branch had profoundly overstepped its constitutional boundaries.
The president can't just bypass Congress to raise revenue, even if it's disguised as an immigration policy.
Exactly. It's a classic separation of powers issue.
But the legal research from our attorneys highlights that the judge didn't just stop at the Constitution. There was a whole secondary mechanism used to dismantle this, rooted in the Administrative Procedure Act, or the APA. Let's get into the mechanics of the APA, because I don't think most people realize how much this specific law governs their daily lives.
Oh, it's huge. The Administrative Procedure Act is essentially the rule book for how federal agencies are allowed to make rules. It was designed to prevent the government from acting like a dictatorship.
Right.
When a federal agency wants to implement a massive change like altering an immigration fee or changing an environmental standard, the APA requires them to go through a rigorous process called notice and comment.
Which basically means they have to publish the proposed rule, tell the public what they are doing, and then give everyone a chance to complain or offer data, right?
Yes, and the agency is legally required to review those public comments and respond to them. They have to conduct economic impact analyses. They have to prove that their new rule isn't just arbitrary.
And did they do that here?
Not at all. The court found that the administration completely bypassed the APA. They didn't do notice and comment. They didn't do an economic study. They just dropped a $100,000 bomb by executive proclamation. Therefore, the court ruled the action was arbitrary and capricious.
Arbitrary and capricious. That sounds bad.
It is the legal death knell for an agency rule. If a judge calls your rule arbitrary and capricious, it's over.
And this brings us to what I think is the most powerful concept in the entire deep dive today. Let's look at the remedy, because I know you're wondering this if you're listening. If California and Massachusetts sued the government and the judge in Massachusetts ruled in their favor, why does this help Vikram's employer in Texas? Texas wasn't a plaintiff. Why doesn't the government just say, fine, we won't charge the fee in those 20 states, but Texas still has to pay it?
That is the exact defense the government tried to use in court, and it brings us to a concept known as APA Vacatur.
Wait, what does that actually mean? APA Vacatur. Does it just shield the people who filed the lawsuit?
No, and that is what makes it so incredibly potent. When a federal court issues an injunction, It sometimes only applies to the specific plaintiffs, like, okay, California, you're exempt. But when a court finds that a government agency violated the Administrative Procedure Act, the standard remedy under the law is to vacate the agency's action entirely.
Vacate, meaning?
Vacatur operates on the rule itself, not on the people suing. It literally erases the rule from the Federal Register entirely.
Wow, it just deletes the code from the system.
Precisely. Judge Sorokin ruled that because the rule was fundamentally unlawful in its creation, it cannot exist anywhere. It is completely erased from the legal landscape nationwide.
So the administration cannot selectively enforce an unlawfully created tax in Texas while pausing it in Massachusetts.
Right. For now, across all 50 states, the fee simply does not legally exist.
That is a staggering level of judicial power. It's total erasure. But look, here is where we need to heavily pivot into the reality of the situation today. I was looking at several immigration forums this morning, and the level of panic and misinformation is just off the charts.
Oh, I'm sure. It always is after a big ruling.
People are drawing wildly inaccurate conclusions about what this erasure actually means for their pending applications. So let's rely on the legal research provided by our team to methodically address the chaos and get to the truth of what is happening on the ground.
Yes, because the misinformation vacuum is incredibly dangerous right now. Employers could make catastrophic strategic errors if they misinterpret the scope of this ruling. What is the primary point of confusion you are seeing in the forums?
The biggest one is a complete misunderstanding of the program structure. People genuinely think the entire H-1B system was just rewritten by this judge. Like, I literally saw comments asking if the 65,000 visa cap was gone now that the fee was struck down.
That is a fundamental misreading of the ruling. The court struck down the $100,000 surcharge, period. The foundational architecture of the H-1B program, as designed by Congress, is completely untouched by this lawsuit.
So the caps are still there?
Absolutely. The annual statutory cap of 65,000 standard visas remains. The 20,000 additional visas for U.S. advanced degree holders remains. The lottery system, the electronic registration process, is still the gatekeeper.
And the strict eligibility requirements, the prevailing wage obligations, none of that was challenged, right?
Exactly.
Rome, 20,000 spectators, one epic battle, two warriors, one destiny. But before they can fight for glory, they must face the real challenge, getting their visa approved.
If you want to enter, show me your visa.
They should have went to the law offices of Chris M. Ingram. They are very good.
Yes, I've heard the same. They handled my visa in no time.
Off to the lion's pit.
Come with me, boys. It's dinner time.
Because even legends need the offices of Chris M. Ingram.
Are you looking for a visa? Why don't you get your free consultation on the Breakthrough website? We're with you every step of the way.
Employers must still obtain a certified labor condition application from the Department of Labor, proving they're paying the required prevailing wage for that specific occupation in that specific geographic area.
Right, because if you are a software developer in San Francisco, your required wage is very different than a software developer in Ohio.
Yes, and the employer must still prove they meet that threshold to protect U.S. workers' wages. Judge Sorokin's ruling was incredibly narrow. It was strictly about the legality of one specific, highly irregular $100,000 fee. It did not magically deregulate the U.S. immigration system.
Which flows right into the second major piece of confusion I'm seeing. Because this massive financial barrier is gone, some HR departments seem to think it's a free-for-all. Like they can just spam applications without consequences. Oh, the $100 K fee is gone. Let's just file 50 petitions today. But there are still significant costs and hurdles, aren't there?
Absolutely. The idea that H-1B sponsorship is now cheap or easy is a dangerous assumption. While the unconstitutional surcharge is gone, the standard lawful fee structure is fully enforced. Let's break down those actual costs.
Yeah, what are they actually paying?
Depending on the size of the company, an employer is still paying a base filing fee, an ACWIA fee for American worker training, a fraud prevention and detection fee, and often a premium processing fee if they need a rapid adjudication. All told, standard government filing fees still run anywhere between $2,000 and $5,000 per petition.
And that's just the government's cut. That doesn't include the legal counsel required to actually build the petition.
Right. As our attorneys consistently advise, the removal of the massive surcharge is a financial relief, but it does not alter the strategic reality of the adjudication process. USCIS officers are still rigorously scrutinizing every single petition.
Like, does the job actually require a bachelor's degree in a specific specialty?
Yes. Does the candidate's degree perfectly align with the job duties? A poorly prepared, rushed petition is still going to result in a request for evidence or a flat-out denial. The standard of proof hasn't been lowered just because the price tag normalized.
So employers are still very much on the hook for standard processing fees and intense scrutiny. But what about the companies that panicked earlier this year and actually paid the $100,000? Where does that money go now? Because I'm seeing a lot of assumptions that massive refund checks are already in the mail.
Yeah, this is where we have to look closely at the data provided in the legal research, because the narrative of massive refunds doesn't actually align with the reality of who paid this. The psychological footprint of this fee was nationwide, but the actual financial footprint, the money collected, was surprisingly tiny.
The research notes that USCIS confirmed in a court filing that as of mid-February 2026, exactly 85 employers had paid the fee. Just 85 out of the hundreds of thousands of companies that normally participate in the H-1B ecosystem. They collected a total of $8.5 million. Why was that number so remarkably low?
It was low because of the highly specific and somewhat convoluted way the original September 2025 proclamation was written. The $100,000 charge was not a blanket fee on every single H-1B petition.
Wait, really? Who did it apply to?
It strictly applied only to H-1B beneficiaries who were physically outside the United States at the time of filing and who did not already hold a valid H-1B visa stamp in their passport.
Let's unpack that.
Right.
So if a tech company was hiring someone who was already in the U.S. on a student visa, like an F-1 visa, and they were doing a change of status to an H-1B, they didn't have to pay the $100,000.
Correct. They were completely exempt. Furthermore, existing H-1B holders who were already working in the U.S. and just needed to extend their status or amend their petition to change employers, say, moving from Google to Apple, they were also exempt.
Oh, wow.
The proclamation was surgically targeted at new offshore talent coming in from the outside. People exactly like Vikram.
Ah, so that explains the scarecrow analogy we talked about earlier. The government planted this massive, terrifying $100,000 scarecrow in the middle of the field. And if you look at the raw data, you might say, well, the scarecrow was a failure. It only caught 85 birds. But the purpose of this scarecrow wasn't to catch birds. The purpose was to terrify millions of birds into never flying into the field in the first place.
That is the perfect way to visualize the chilling effect. The true damage of this policy wasn't the $8.5 million sitting in a government account. The true damage was the frozen pipeline.
The fear.
Exactly. It was thousands of corporate boards and HR directors looking at that scarecrow, pausing all international hiring and deciding not to file at all. The ruling today doesn't just trigger refunds for the 85, it thaws the entire frozen pipeline for the hundreds of thousands who were too scared to proceed.
But for those 85 employers who did pay, what is the actual mechanism for getting that money back? Have they announced a streamlined refund process?
Not yet, and our legal team stresses caution here. Never, ever assume that extracting $100,000 from the federal treasury will be automatic or fast.
So what should they do?
The immediate play for those 85 companies is aggressive, pristine record keeping. They need to document the exact wire transfers, the internal correspondence detailing the payment, the USCIS receipt notices, and have everything prepared for when the agency finally issues formal refund guidance.
Okay, let's move to the most critical warning of this entire deep dive. If I'm an employer listening to this and I hear that a federal judge erased the rule nationwide, I'm probably thinking this is over. We won. Let's get back to business as usual.
And that would be a mistake.
Right, because looking at the timeline, the administration has an immediate out here. They aren't just going to accept this ruling and walk away, are they?
No, they are absolutely not. And this is where employers must understand the friction within the federal appellate system. We do not have a single unified legal outcome right now. We have a fractured landscape. Well, Judge Sorokin's ruling in Massachusetts declared the fee an unconstitutional tax. But we have to look back to December 2025. Another federal judge in Washington, D.C. looked at a nearly identical legal challenge to the exact same fee and reached the exact opposite conclusion.
Wait, so a federal judge in D.C. said this $100,000 fee was totally legal. How is that possible if it violates the Constitution?
Because the D.C. judge approached the case from a completely different angle of precedent. The D.C. ruling leaned heavily on the precedent of broad executive deference in immigration matters.
Executive deference, what does that mean in this context?
Historically, and particularly citing cases like Trump v. Hawaii, the Supreme Court has given the president massive latitude to restrict entry into the United States based on national interest. The D.C. judge interpreted the proclamation not as a tax, but as a lawful mechanism to restrict entry, arguing the president has the authority to use financial conditions as a tool of border control.
So we literally have two federal judges completely disagreeing on whether this is an illegal tax or a legal border control tool.
Yes, and to further complicate the map, there is a third major lawsuit currently pending in federal court in San Francisco in the Ninth Circuit. So we could ultimately see divided, conflicting rulings across three separate appellate circuits: the First Circuit for Massachusetts, the D.C. Circuit, and the Ninth Circuit out west.
It sounds like a fast track to the Supreme Court. But in the immediate short term, what is the White House going to do about the Massachusetts ruling? Couldn't this fee snap right back into place by Friday?
That is the exact danger our researchers are warning about. The White House has already signaled their intent to appeal the June 8th decision to the First Circuit Court of Appeals. And when they appeal, they will file a motion for an emergency stay.
Okay, explain the mechanics of emergency stay for the listeners. What actually happens in the courtroom when they do that?
An emergency stay is essentially a request by the losing party to pause the judge's ruling while the lengthy appeal process plays out. The government will argue to the appellate court that if the fee isn't collected right now, the government suffers irreparable harm.
And if the court agrees?
If the First Circuit panel agrees and grants the stay, Judge Sorokin's order of vacatur is temporarily suspended.
Which means the $100,000 fee is instantly reactivated. The scarecrow goes right back up in the field.
Precisely. As the research from attorney Chris Ingram bluntly warns, in the realm of immigration litigation, a win today can be stayed tomorrow. The legal battle is absolutely not over. The window of opportunity is wide open right now, this very minute, but no one can guarantee how long it will stay open.
That is incredibly sobering. It completely changes the dynamic from we won to we need to move fast, which ties directly into the final misconception I want to clear up. Some people assume this ruling only matters for companies filing brand new first-time H-1B petitions next year. But the macro data suggests the implications are much, much broader.
The implications affect the entire trajectory of the U.S. innovation economy. To understand why, we have to look at the macro data regarding the talent ecosystem.
Let's hear it.
Let's look at the official USCIS registration numbers before and after this fee was introduced. In fiscal year 2024, the total number of H-1B registrations entered into the lottery was around 780,000. For fiscal year 2027, under the crushing weight of this $100,000 fee, industry estimates projected those registrations would plummet to somewhere between 200,000 and 250,000.
That is a staggering drop. We are talking about 500,000 highly skilled individuals, engineers, doctors, AI researchers, just disappearing from the U.S. pipeline.
It is a total collapse of the pipeline. And as the American Immigration Lawyers Association, which attorney Chris M. Ingram is a member of, pointed out when the fee was first imposed, this policy was inflicting needless, self-directed harm on the country's economic competitiveness. The ruling in Massachusetts finally begins to reverse that massive talent drain.
Because it changes the global conversation overnight. I mean, the workers who were sitting in Bengaluru or London Googling, should I move to Canada instead of waiting for my H-1B, or wondering if the U.S. was permanently closed to them? This ruling gives them a reason to reconsider.
It does.
It wasn't just a financial obstacle. It was a psychological barrier that broadcasted a very clear message. You are not welcome here unless your employer is impossibly wealthy.
And removing that psychological barrier is a massive signal to the employers, too. Companies that completely dismantled their sponsorship programs in late 2025 now have a compelling, legally backed reason to pull those plans out of the trash and revisit them.
Which brings us back full circle to Vikram. The research shares exactly what happened the morning after Judge Sorokin's ruling came down. It's an incredible moment that proves the value of agility. It wasn't HR who called him. It wasn't a generic automated company email. It was his direct engineering manager calling him on his cell phone before 9:00 a.m. in Austin.
Yes. The manager basically said, "We saw the ruling. We are moving forward today."
7 months of agonizing patience, of watching his peers leave for the UK, of wondering if his entire life plan was derailing, and it ends with one phone call before breakfast.
But we have to emphasize why that phone call happened so fast. It happened because the company's legal counsel had already been briefed overnight. They were actively tracking the litigation on the federal dockets. They knew the emergency stay was a threat, so they were ready to move the exact second the injunction hit the wire. Speed comes from preparation.
And that leads us perfectly into the strategic action plan.
Yeah.
Because knowing the fee is down is utterly useless if you don't act on that knowledge before an appellate court potentially issues a stay. Our legal team at BreakthroughUSA.com has provided a clear, tactical roadmap. Let's break down exactly what you, the listener, need to do the moment this deep dive ends. The first step is about taking initiative with your employer.
Right. If you are an employee whose H-1B sponsorship was paused specifically because of this $100,000 fee, you cannot sit back and assume your HR department is monitoring federal court dockets in Massachusetts.
Right. HR is busy.
Exactly. HR deals with payroll, benefits, and 100 other daily crises. The barrier that caused your pause is legally gone right now. You need to be the catalyst. You need to bring the ruling, the legal briefs, the news articles directly to your HR or corporate counsel and politely request to restart the conversation.
I think that is incredibly empowering. You don't have to be a passive victim of bureaucracy. You can literally take this research, point to the APA Vacatur and say, the financial math that paused my hire yesterday has fundamentally changed today. Let's file. The second critical action item focuses on a very specific subset of applicants.
Yeah.
Those on OPT or STEM OPT. Why is time so critical for them right now?
Because of hard, unforgiving deadlines. OPT optional practical training and STEM OPT are temporary work authorizations granted to international students after they graduate from a U.S. university, but they have strict expiration dates.
Right.
For 7 months, this $100,000 fee severely disrupted the timeline for transitioning from that temporary student OPT status into a dual intent H-1B status.
Because if your OPT expires before your H-1B is filed, you fall out of status, you lose your right to work, and you might literally have to pack up and leave the country.
Exactly. There are 60-day grace periods and complex rules surrounding the cap gap extension, which allows some students to keep working if their H-1B is pending. But rebuilding a petition strategy, getting the labor condition application certified, and assembling all the documentation takes weeks.
It's not an overnight process.
No, it isn't. If your OPT is expiring in the next few months, time is your absolute worst enemy right now. You need legal counsel immediately to evaluate your remaining timeline and file before an appellate stay potentially drops.
The third action item is for those 85 employers who actually paid the $8.5 million. We touched on this, but what is the exact mechanism they should be preparing for? USCIS hasn't said a word about how to get that money back yet.
And they likely won't say a word until the Department of Justice decides on their entire litigation strategy. But employers need to prepare a dedicated audit trail today. Do not wait for the government to ask.
So, gather the receipts.
Yes. Gather the cleared wire transfer records, the specific Form I-129 receipt notices associated with the surcharge, and all internal communications authorizing the payment. When USCIS eventually publishes the Federal Register notice detailing the refund mechanics, the companies that have a pristine, attorney-reviewed paper trail will be at the front of the line.
The fourth point from our researchers is a reality check. Respect the remaining obstacles.
Yes. Removing the $100,000 surcharge does not magically print an H-1B visa and place it in your passport. The foundational hurdles are still incredibly high.
Right, like the lottery.
Exactly. Demand still vastly outstrips the $85,000 annual cap, meaning the lottery is still intensely competitive. Strict prevailing wage requirements are still aggressively enforced by the Department of Labor. The strategy here is not to assume the process is suddenly easy. The strategy is to use this newly opened window while acknowledging that the standard, rigorous legal hurdles require meticulous preparation.
And the final action item brings it all together.
Yeah.
Watch the government's next move.
Agility is the only currency that matters right now. In a landscape where we have conflicting rulings between the D.C. Circuit and the Massachusetts Circuit and an imminent appeal to the First Circuit, hesitation is a strategic failure.
You have to move.
The barrier's gone today. You must act today. Do not schedule a meeting to discuss this next month, because next month an emergency stay could be fully in place.
The legal ground is violently shifting beneath our feet, but for the first time in 7 months, it is actually shifting in favor of the applicants and the employers who need them. It's entirely about seizing the momentum of this specific moment in time.
It really is. And, you know, if we step back from the complex legal maneuvers, the APA, the vacatures, the emergency stays, and look at the macro picture, what stands out to you the most about this entire saga?
What stands out to me is how terrifyingly fragile the plans of so many brilliant people really are. We're talking about individuals like Vikram who did everything exactly right. They studied relentlessly, they navigated complex university systems, they proved their immense worth to American companies, and they followed every single rule.
Yeah.
And yet, with a single stroke of a pen on a presidential proclamation, their entire future was nearly wiped away. It brings us back to that opening thought about the earthquake. The federal judge just patched the massive crack in the foundation. We survived the initial shock. But the landscape isn't exactly the same as it was before the quake, is it? The trust is fractured.
It is severely fractured, and that raises a profound, long-term question that goes far beyond the mechanics of constitutional law or fee schedules. The law isn't just words printed in the Federal Register. It's a living, breathing ecosystem that directly dictates human potential and global innovation.
Exactly. The psychological impact lingers long after the injunction is signed.
So here's a final thought to ponder as we conclude today's deep dive. Even though Judge Sorokin struck down the fee, and even if the appellate courts ultimately uphold his ruling and reject the government's appeals, how long will it actually take to rebuild the trust of the global talent pool?
That's the real question.
We just forced the world's best engineers, scientists, and AI researchers to sit in an agonizing limbo for 7 months, watching an unpredictable, volatile system toy with their lives and their careers. When a country abruptly puts a $100,000 price tag on entry, does the legal removal of that price tag instantly restore the perception of the American dream? Or has the global talent market people, exactly like Vikram and his highly skilled peers, permanently shifted its gaze to countries that don't subject their futures to these kinds of devastating legal earthquakes?
That is a heavy, necessary question. The $100,000 scarecrow might be gone from the field today, but the birds definitely remember it was there. Thank you so much for being with us today. We hope you gained a lot from this discussion. Please leave us a comment if you can. Additionally, you can support our channel by sharing it with your friends and family, helping us build this community together. Also, follow us on Spotify, YouTube, LinkedIn, Facebook, X, and Instagram, where we're growing rapidly thanks to our social media team. We would also like to thank attorney Chris Ingram and his dedicated team once again for researching and preparing this material for our presentation. See you next time on Let's Talk U.S. Immigration. Bye for now.